Greetings, test takers. This is Dean Tinney. I'm coming to you from my studio in fabulous Las Vegas. One of our most popular items on the YouTube channel, my YouTube channel, is practice exams. And we're going to be explicating. Explicating means talking about right answers, wrong answers, going through it. And this is for the 63. So I'm happy to finally have built the channel to the point where we can start backfilling some of the series playlists may be a little thin. And we are able to do something kind of unique. This actually looks a lot better in its form. I've turned it into a Word doc for the explication. But my channel is a free supplement to your paid study materials. And Test Geek Exam Prep LLC is a paid supplement to your study materials, your paid study materials. And the managing member, Brian Lee, is allowing us, our viewers and subscribers, to get a free look at some of the content in his paid supplement. And that's what we're going to be looking at today is some of Brian's, paid supplement. In fact, what I have on the screen right now is a version of Brian's quick notes. And so what he actually does here is he goes through the exam, as you can see, pretty nice looking. And then we're going to be doing today the 63 practice final. And Brian is trying to be a bridge from your study materials to the exam. There is correlation on this. And not only do our viewers and subscribers get a free look that we're going to be doing here in just a sec and be able to use this, but you also get a 20% discount as a viewer or subscriber to the channel. And that discount code is Guru 20. So if you just want to get this practice exam, so I'm going to be going through it and I'm going to explicate it. I'm going to be marking it up. And if you want a PDF of the practice exam and the answer key, you can just for $20 get a copy PDF of that. Now with the 20% discount, that's 16. And if you want the quick notes, the class notes, that's this nice little beautiful looking thing. It looks much prettier than I have it displayed here on the screen because like I said, I've turned this into a Word document for the explication. But that is $29.95, and with our discount, that's $24. And then if you want to get the entire paid supplement from Test Geek, which includes all of Brian's 63 videos, that is going to be $79, but with the discount, that's $63.20. So that is part of our collaboration. I also have one of the most popular lectures, so I'm going to put a link to in the video description to Test Geek. I'm also going to put a link to Mighty 90. My Mighty 90 is one of our most popular lectures. It's very target rich. It's 90 minutes on 63. So I'll link to both of those so that you can get some additional resources if you like. All right, so let's get started on the explication. Now, if you want to use this as an intellectual inventory of where you're at in terms of intellectual ownership of the content on 63, maybe you hit the pause button as I go through this and see what your answer was and whether or not you got it right. Let me set our little timer, try to get these things done in a timely fashion. But there's a pause, so you can always, if it's too much for you, take a pause. But, you are going to be doing 60 questions here. All right, so an agent of a broker-dealer for the past 10 years decides to resign to go into business with her brother-in-law. Which, if any, are required to notify the state administrator? The most important participant in the 63 is the state administrator. I kind of think of the SEC as God and state administrators think they are. And so as a resident of a particular state, I actually have two levels of protection. I have the SEC, and I also have my state administrator as a retail customer. Please note, retail customer. So the answer to number one is C. Whoop, I hope I could do a little bit of that. C. Both the broker-dealer and the agent are required to notify the state administrator. Number two, a broker-dealer in state A has its license canceled. An agent for the broker-dealer may continue to conduct business. No, I mean, you can't be an agent of a broker-dealer in good standing if the broker-dealer is not in good standing. So B, no. C, if you've lost the firm, or the firm is no longer able to conduct business, then you are no longer able to conduct business. So the broker-dealer has its registration canceled. You too cannot conduct business. You're going to be canceled along with that. So the answer is C. According to the Uniform Securities Act, which of the following is required to register an agent of a broker-dealer. By the way, this is kind of like a legal test. And so if you're taking the 63, you're typically an agent of a broker-dealer. That means you've taken a 6. There's others, but 6 or 7. And so now you're telling the state administrator, I'm going to be an agent of a broker-dealer. So this should be, for a lot of you, the last leg of your testing journey. All right, so who's required to register as an agent? 1, a partner of the broker-dealer who is a majority owner of the broker-dealer. A partner of the broker-dealer who manages the firms and all its related activities. An employee of the broker-dealer whose major function is to take orders from the public on behalf of the firm's owners. An employee of the broker-dealer only trades securities for the broker-dealer's account. Now, this one's kind of tricky. You know, a lot of state administrators say because of all the information that a broker-dealer provides when registering with the state, sometimes the partners will be automatically registered. But there's no doubt that the key point here, number 1, is a silent partner. And this would have been very easy to miss, but you shouldn't have been struggling. You should not have been able to been struggling with particularly number 2, 3, and number 4. 4, according to the Uniform Securities Act, an employee of a broker-dealer may sell securities as an unregistered agent. Yeah, under no circumstances, right? I mean, you can't sell securities in the state unless you are registered as an agent of the broker-dealer in the state. Now, be careful on that. So, you know, we have exempt transactions, we have exempt securities, but it doesn't matter if you work for broker-dealer, it doesn't matter whether the transaction or the securities exempt, you need to be registered, properly registered. So the answer to 4 is A. An agent whose registration took effect November 11th, 2008 would find the first renewal would take place. Now, you don't get a whole lot of aim and shoot, point and click questions on this exam. And so when you do, you definitely got to make sure you get them. And this is December 31st. That's true of everything, right? Every year, December 31st, this is 2008. And so it'd be 2008, December 31st. The investment advisor is meeting with a new prospect. Which of the following performance data could be presented? So, you know, what this is saying is that, you know, I'm not a particular fan of this question of Brian's, but what it's saying is you can't cherry pick. You know, you've got to show your entire universe, not just what you'd like people to see. And so the answer to 6 is D. Now, I don't particularly care for the question itself, but I do like the intellectual takeaway for the test, which is I can't cherry pick, you know, what I'm going to be presenting in terms of performance data. I got to show you my flowers and my weeds, all of it, you know, all the accounts. An investment advisor representative works for a federally covered investment advisor. So some of you taking your 63, I'm going to tell you now, you may take another exam because with a 63, you're an agent of a broker dealer. But a lot of broker dealers have affiliated investment advisory firms. And whether it's an affiliate investment advisor firm of your broker dealer or an independent investment advisor, if you're going to represent an investment advisor, you need a 65 or a 66. So first main point, this ain't you. This is somebody who's taken and passed a 65 or 66. And in the investment advisory world, we have what are called federally covered investment advisors, and we have what are called state covered investment advisors. I have a lecture on this. It's called Who's Your Daddy? And what that means is the investment advisory firm is either going to be registered with the SEC or it's going to be registered with the state, never both. I'll probably link to that narrative lecture as well. So 2 narrative lectures that will help you on your 63 journey are the Mighty 90 and Who's Your Daddy? All right, so the investment advisor travels to see clients in state B. So as a federally covered investment advisor, my investment advisor reps, my 65s, my 66s, are going to register in the home state of the federally covered investment advisor and may or may not have to register in other states. So let's look at our answer set on number 7. The investment advisor need not be registered in state B. That is true. As a federally covered investment advisor, this is different on the state level, but for federally covered, unless I have a place of business in state B, I do not need to be registered in state B. So that is true. By the way, don't bringing extra stuff to the question. It doesn't say anything about, you know, having an office. The investment advisor rep need not be registered in state A. Now, The investment advisory firm isn't going to register in state A, but the 65 or 66 certainly is. And so here, let's see what our next one is. Number 3. The investment advisor rep needs to be registered in state B. We say, nope, right? Need not be registered in state B. By the way, 1 and 3 are mutually exclusive. So 4, the investment advisor rep needs to be registered in state. Yeah. The state of the home office. So it's 1 and 4. And so the answer is B. If a state registered investment advisor has its principal office in state B and 3 other states. So again, we're not talking about broker dealer. It's really important that when you're taking your test, you're really clear about what the question is about. Is it about a broker dealer or is it about an investment advisor? Because those regulatory frameworks are a little different. This is a state registered investment advisor, not federal. Its principal office is in state B and 3 other offices. The investment advisor. Now, the investment advisor, by the way, is the firm. It's not the investment advisor rep. It's the firm. And the answer here is meet the capital requirements of whatever the home state is, which in this case is state B. States can impose on investment advisory firms net worth requirements of either 10 or 35 grand, depending on the type of custody they have. And who cares? The point is, you don't have to meet every different version of this. By the way, the Uniform Securities Act is a template. It's not the actual laws of a particular state. It's a template you're being tested on, where the North American Security Administrator Association has been kind enough to say that if you can pass it, you can conduct business in their state, which is, thank goodness. Otherwise, you'd have to take 50 different exams. So the answer to 8 is A. 9. If a federally registered investment advisor has its principal office in state A, an office in 3 other states, so far it doesn't matter because that's the whole point of being federally covered. If I'm federally covered, who's my daddy? It's the SEC. So as an investment advisory firm, I'm not going to have to, register with any state. I'm registered with the SEC on the firm level. It says an client of the investment advisor rep who's in state A moves to a state in which the investment advisor rep is not registered. Then the IRR, we kind of had a very similar question here earlier. And the answer is, I don't have to do anything. If I'm working for federally, the only time I am going to have to register in another state as an investment advisor representative of a federally covered investment advisor is if I have a place of business in that state. So that the answer is A. 10, a Canadian broker dealer wanting to do security transactions with his clients who are Canadians or vacationing in the United States. It says open an office U.S., register 1 state, open an office all states. You could kind of toss that out. That doesn't really make any intellectual sense. It's kind of ridiculous. Do not open an office, but register in the states where the clients are vacationing. So even if you are Canadian, you have retail clients who are in the state, then, you're going to have to let the state administrator know that you're doing business in that state. The answer to 10 is C. A federally covered advisor has its own office in state A. It solicits 5 customers in state B, and it holds a seminar in state C. Now, remember, there's a difference between the regulatory framework for a state covered investment advisor. That regulatory framework is a lot different and has a lot more complexities than being a federally covered investment advisor. We said part of being a federally covered investment advisor is you're not registering in any state. A federally covered investment advisor just registered with the SEC, never both. It's either going to be the SEC, state, or states. It's not going to be SEC and state. It's not going to be states and SEC. It's one or the other. So once the investment advisory firm is registered with the SEC, they're not going to have to register in any state. Now, be careful. There's a difference between asking about the advisor, the federally covered advisor, the firm, versus asking you about an investment advisor rep of that federally covered advisor. We've encountered that a couple of times, right? We said the investment advisor rep of a federally covered advisor is going to register in state A in this example. We're not asking about that individual. And then maybe in this exam, in this question, not state B, not C. They only have to register as an individual, an investment advisor representative, if they have a place of business in that state B or state C. Under the right of rescission, very likely you're going to see this high probability on the test. So make sure you understand the right of rescission. The right of rescission on the Uniform Securities Act is saying to the customer, listen, we blew it. We call this the blue sky. We're supposed to have been registered in the state as a broker dealer because we had a place of business in the state, our retail clients in the state, and we did not. We were supposed to register the security through either coordination or through qualification, and we did not. Our rep was supposed to be registered state and was not. So for whatever reason, we didn't get this done in the proper way in terms of registering it. And so now I'm going to come to you as a client and say, I'd like to offer you the right of rescission. And the answer here is it's 3 years, the retains the right, 3 years from the purchase or 2 years from the discovery. Now, if you're going to buy the PDF for $16 from Brian, Test Geek Exam Prep LLC, one thing I might recommend that you do is what I call poor man's or lazy man flashcards. If not, you can just stop, this discussion, hit pause, and see how you do on the test, but the question that's being proposed here. But you can also hit pause to make your own flashcard. And I think this is a good flashcard. So if you buy the PDF from Brian, what I might recommend you do is what I've just done here. And then what I would do the night of or morning of my exam or both is go through and read all my poor man, lazy man flashcards. So now I have one that says, under the right of rescission, a customer who has unlawfully sold a security retains the right to sue for 3 years from the purchase or 2 years from discovery of the infraction. So I think that's a good way to proceed. If you don't want to buy the paid supplement, that's fine. You might want to consider just making your own flashcard. Don't ask me to send the paid supplement PDF to you because I won't do it. Anyways, 13. According to the Uniform Securities Act, which of the following is considered a sale? So an offer accepted becomes a sale. It becomes a transaction under the Uniform Securities Act. And so what this question is about is, does the state administrator have jurisdiction for the sale that took place? And so 13 says, giving a security as a bonus. One thing you might want to do is maybe you say, well, I'm not sure about that one. Maybe you put a question mark to it. Making a bona fide loan of stock. So you definitely should know as a test taker that if somebody pledges securities as a collateral for a loan, bona fide means Latin for good faith. I, the person who accepted that collateral for the loan, can sell those securities. It's not considered a sale or transaction under the Uniform Securities Act. So I definitely think you as a test taker need to know that making a bona fide loan of stock means the state administrator does not have jurisdiction or authority because it's not a sale in the Uniform Securities Act. So now as a test taker, what I'm going to do is I'm going to eliminate any answer offered to me that has a Roman numeral 2 in it. So in terms of test taking skills, we're now going to say, okay, well, I need to get rid of any answer that has a 2 in it because I should know that that is not true. And that's kind of helpful because now that means I don't need to burn up brain cells on Roman numeral 3 because I'm going to have to take Roman numeral 3. Giving a security as a bonus. Now, the key word there that makes that problematic is a bonus. One of the things you're looking for is if there was consideration or not. And here, the answer is going to be C. Ooh, got my wrong thing going on here. Is C. It's 1 and 3. Now, again, it's not so much that it's 1 and 3, it's that you know that 2 is not. That is the takeaway from this, this question. Let me clean up my. According to the Uniform Securities Act, very testable to know what is not a person on the Uniform Securities Act. As I mentioned, this is a legal test. And so it's not only the Uniform Securities Act, it's also, actually, there's Uniform Securities Act, there are templates, there's more than kind of one, but it's a template. Anyways, the point is, minors are not considered to be persons. Persons legally are people who can be held accountable for their behavior. And on your exam, we have 2 types of persons. We have natural persons who are living, breathing human beings walking planet Earth. And we have unnatural persons. Unnatural persons are not living, breathing human beings walking planet Earth. Unnatural persons would be, for example, your broker dealer, the investment advisor, the issuer. So the corporation is a person. It's a natural person that can be held legally accountable. A joint stock company, again, unnatural person can be held accountable. The US government, yes. Now, the other ones I would know on the test, now let me put that here. So besides knowing that a minor is not a person, now I like Brian, he's trying to cloud your mind that it's a prodigy worth millions. That has nothing to do with whether you can be legally held accountable. And the other persons who are not considered persons are somebody now deceased. And I would also know somebody who's been declared legally incompetent. Legally incompetent means they're incompetent of handling their own affairs. You know, you probably saw the mob movies, for example, where, you know, the mobster at the last minute says, oh, I'm been declared mentally incompetent. In fact, let me just change that to say mentally incompetent. So definitely make sure as a test taker, you know who is not a person on your 63. An agent of the broker dealer, I don't know if it's helpful, but when I think of the agent of the broker dealer, I think of it being me, right? This is I have my 6, I'm taking my 63, or I have my 7 and I'm taking my 63. And the reason I'm taking this 63 is so I can be an agent of a broker dealer. And the home office of my broker dealer is in state A. Now be careful, as I've warned you, you've got to be very careful whether you're being asked about investment advisory firm or broker dealer, because it's much different. This is not a question about an investment advisor. This is a question about a broker dealer. So an agent of a broker dealer whose home office is in state A has a client in state B and has their mail forwarded to state C. So again, I'll just use Schwab. I'm a 7. I'm a Schwabi taking my 63. The home office is in Westlake, Texas, and we have a customer in North Dakota. And the customer in North Dakota has their mail forwarded to, Phoenix, Arizona. Now, how am I supposed to know that you're forwarding your mail to state C? And so I'm only, as an agent of the broker dealer, going to have to be registered in state A. And state B. The answer to 15 is C. Both the investment advisor and the investment advisor representative. So the investment advisor is the firm, a natural person. The investment advisor representative is a natural person, living, breathing human being, taking a 65 or 66. The numeric requirements aren't testable. I'm just saying it ain't you as the boy. They do not renew their registration until March 30th. Now, I've seen this a couple of times. Which of the following is true? Right? So all registrations, that's testable December 31st. Now, the only thing that doesn't need to be renewed, remember, is your consent to serve it. That's a permanent part of your record. There's no renewal on that. As long as the firm is around and you're around, that's a permanent part of your record. But other than that, December 31st is going to be something you should be aware of as a test taker. All right, 17. An individual employed by a federally covered advisor would be required to become registered as an investment advisor rep in the state. So we said, if you work for a federally covered advisor, you know, that's somebody who has assets under management of 110 million or more, or 100 million or more, depending on the scenario. But the point is, we said that federally covered advisor is not registering with any state. And we said the 65 who works for that federally covered advisor is going to register in the home state of the wherever the principal office of that advisor is, and then only has to register in another state if they have a place of business. And so, A, the only clients receiving individual advice are large pension plans organized for employees of municipalities. We're that individuals. There's the key. The rest of that has nothing to do with answering this question. The thing that kicks off the registration of that 65, that investment advisor rep in the state, is they have an office in the state. And so let's see, no office. D doesn't really make it forthcoming. 17 is going to be A, not because of the pension plans or the employees. That's just distractors. It's because there's an office in the state. There's an office in the state. 18. Under the Uniform Securities Act, when an investment advisor representative is acting in the capacity of a trustee for a family trust, executing a transaction on behalf of the trust, What they're trying, what I think Brian is trying to do in this question is confuse you about a trustee in bankruptcy. If I'm a trustee in bankruptcy appointed by a judge, I can, do securities transactions. Remember this: transactions, offers, sales. And the state administrator does not have authority or jurisdiction over transactions done by a fiduciary appointed by the court, like a trustee in bankruptcy. That is not this trustee. So this is a non-exempt transaction. The exempt transaction would be for a trustee in bankruptcy. Anyways, here, this is a pretty routine thing that, 65, 66s, set up trusts and manage trusts and become trustees for customers. 19, Sharon Smith is an agent for a broker-dealer registered in all 50 states. Sharon receives an unsolicited order from a bank located in state X, a state in which he has no place of business. Now, be careful. This again is the broker-dealer. So, Sharon Smith is an agent of Schwab. Schwab is registered in all 50 states. Sharon receives, she's the one picking up the phone, from a bank located in the state X, a state in which she has no place of business. Who cares? The place of business has nothing to do with broker-dealer in this scenario. Outside of this scenario, if Schwab has an office in the state, any broker-dealer has an office in the state, then the broker-dealer has to be registered in the state. Or if they have a retail customer, they have to be registered in the state. But anyways, that has nothing to do with this question. Under the Uniform Securities Act, because Sharon has no place of business in state X and the client's an institution, she may accept the order without registering in state X. No. Sharon must be registered in state X to accept the order. Yeah. She still has to be registered if she's going to be taking, orders that originate from the state. The state administrator does have jurisdiction over an offer or sale that, originated in their state. So that one's kind of tricky, but the answer to that one is B. There are very, very few exceptions for agents of broker-dealers that do not need to be registered. 20, a FINRA member broker-dealer. So all broker-dealers are registered with FINRA. So, before I retired, I had my own broker-dealer. It was called Gamma Global Investments. And I'm going to register my broker-dealer with the SEC. There's no such thing as a broker-dealer that isn't registered with the SEC. I'm going to register my broker-dealer with the state. My home office is San Francisco, California. I'm going to have to register the broker-dealer in California. In any state in which I have an office or a retail customer. I have no retail customers outside of the state of California, but I have an office in Leesburg, Virginia. So I'm going to have to get the broker-dealer registered in the state of Virginia. I have institutional customers in New York and Texas, but I have no place of business. So, the broker-dealer regulatory framework is a little different than it is for an investment advisory firm. So I told you as a test taker, really be clear about what you're being asked about. You're being asked about the firm as an investment advisor or is the firm a broker-dealer? So broker-dealers are required to have net capital standards. So we're not talking about a net worth requirement for a state-covered investment advisor. No, we're talking about the net capital financial requirements of a broker-dealer. And as a broker-dealer, I only have to answer to the SEC in terms of my net capital standard. So the state cannot impose, this is testable. This is very testable. A state cannot impose on a broker-dealer a higher financial requirement, a higher net capital standard than that imposed on the broker-dealer by its primary regulator, which is the SEC. All right, so 21. An investment advisor is registered in 10 states. So again, the firm here is an investment advisory firm registered in 10 states, and that means it's not federally covered, right? Because if we're either going to be registered with the state or states or the SEC, never both. This is the lecture I will attach to this explicated practice exam. I've got two I'm pretty proud of in terms of a target rich. One is the Mighty 90, and I'll put a link to that for you. 90 minutes, target rich, very popular. And my other very popular lecture as it relates to the Uniform Securities Act is Who's Your Daddy? I'll provide links to that. I'll also provide a link to Test Geek Exam Prep LLC. Anyway, so this state cover regarding the financial requirements. So again, now the state does have authority. Please note this is not a broker-dealer. And so the investment advisory firm only has to meet the net worth requirement, the financial requirements. By the way, be careful. You want to do lots of practice questions because there's a lot of words that got to mean the same thing, like financial requirement, net worth, for brokers, it's net capital, but it's the same general idea. And this is usually on the template. Remember, you're not getting testing on your state's rules, but rather the template. This is typically a 10 grand or 35 grand. But I only have to meet the requirement of my home state, where my principal office is located. So, again, if you're going to be doing poor man's flashcards, we've got a couple good ones here. So, lazy man's flashcards, that's what I'm calling, this version of this. Flashcards are underrated as a study tool. So as I mentioned, if I might want to take these kind of questions and turn them into poor man's flashcards, lazy man flashcards. And as I said, maybe the night before my exam or the morning of my exam, or perhaps both, I just go through it. I read all my questions and my right answers is kind of a warm up. Because, to be honest with you, most people's circadian rhythm does not include waking up and being, wow, I can't wait today to go demonstrate my prowess on the Uniform Securities Act. That's not typical, right? So poor man's flashcards are pretty good idea. Our time's a buffet. You like a suggestion, take it. You don't like it, then don't take it, right? A federally covered advisor has offices in 10 states. Again, doesn't matter. If I'm a federally covered investment advisor, I'm not registering with any state under any circumstances. My reps might have to, but not the firm. And so that's one of the advantages of being a federally covered. So the person, again, I answer to as a federally covered investment advisor is the SEC. Whatever the SEC says, I say, aye. I was in the Marines, so I was teaching today, and somebody said, "What's aye mean?" It means yes, sir. Right? So, that's what we say. Again, maybe you want to turn that into a poor man's flashcard. With regard to the North American Securities Administrator Association. So one thing I recommend is whenever you have an acronym, you just go ahead and turn that acronym into a, spell it out. Sometimes that helps with the grammar. For example, if I have state A, I'm coming to you from Las Vegas, Nevada, I'm going to say Nevada. If they say on the test contiguous state, I'm going to say California. So insert your state or insert your broker dealer, whatever the case may be. In their statement on policy on dishonest and unethical business practices of broker dealers and agents, that would be you, the 6 or 63, the agent. The broker dealer is your firm. Prohibited actions would include accepting an order from a third party after written trading authorization has been received. No, that's fine. If there's the customer has a third party that has the proper documentation to make investment decisions, no problem. Forwarding a written complaint from a customer to my appropriate supervisory person, that's what you're supposed to do. Offering to repurchase a security at its original cost if it does not increase in value. We're never supposed to hold investors harmless in capital securities markets. Their capital's at risk. If they're not comfortable with that, they should not be in the securities markets. Right? Their capital's at risk. If they're uncomfortable with that, they should talk to their insurance agent about an insurance product or their banker about banking products. That is certainly true. That's a prohibition. Borrowing money from a client, big no-no. Big no-no. Now, broker dealers have exceptions for that for immediate family members. That's just my timer telling me we've been at it 30 minutes. And the reason I do that is if you want to, you can take a, hold on just a sec here. I usually in these explications, they come in, I don't know what time they come in whatever they come in. But if you want, you can hit the pause button, take a break, come back and, reconvene. You do want to kind of build up your stamina in terms of doing these, sustained things. I mean, I suggest you have study blocks of 45 minutes, an hour and a half, where you're studying by either doing a practice exam like this or reading your book or watching a video, whatever the case may be. Now I'm going to go ahead and continue to march. I'll reset my timer and continue to march on the explicated practice exam. And I'll set my timer again for 30 minutes. Anyway, so welcome back. If you decided to take a break, and the answer to 23 is D. A savings loan organized in state A is authorized to do business in state B. It has an offering of common stock being made in state B. In order for the individual selling the offering to be excluded from the definition of an agent in state B. So one thing you're looking for is compensation. And so let's see, would have to be employed by the savings and loan. I'm just going back here, and that's in state A, and I'm doing business in state B. I think I'm selling investments in state B is what it looks like to me. I would have to be employed by a broker dealer registered in the other state, state A. I would have to be employed by the broker dealer registered in this state, or I can't sell an investment opportunity in state B unless I'm properly registered. Yeah, that's our best answer given that answer set. 25. An investment advisor rep of a federally covered investment advisor splits his time between an office in state A and state D. Now, what Brian is trying to do here is get you jammed up on thinking this has something to do with de minimis. The de minimis is not for a federally covered advisor. De minimis is for a state covered investment advisor. This is a federally covered advisor, and this is an investment advisor rep. And we said that you're certainly going to have to register in at least one state, the home office in state A. So we definitely know we're going to need state A because, right, it says office in state A. Yeah, an office in state D. So there's a place of business. So it has nothing to do with, by the way, the 16 or the 12 or the 6 or the 4. That would be if you're state covered. The de minimis is for state covered, and that's not what we're looking at here. So I'm going to have to register in state A and state D. C and D, I don't see anything about having a place of business in those states. And so it looks like 25 is going to be B, A, and D, because I have places of business in both those states. So be careful. Just the takeaway as a test taker is de minimis is for state covered advisors, not federal. Under the Uniform Securities Act, which of the following is responsible for notifying the administrator when an agent changes his place of employment from one broker dealer to another? So you're leaving broker dealer A for a better opportunity at broker dealer B. And we're asking who's going to tell the state administrator about this? And it's pretty much everybody, you, the agent, your former broker dealer, and your new broker dealer. So the answer to 26 is A. Included in the Uniform Securities Act's definition of an exempt transaction, would be any transaction the following except. So I brought up this idea of fiduciary transactions being exempt. I gave you one earlier, a trustee in a bankruptcy. And we already earlier said, yes, that would be an exempt transaction. As you recall, remember the trick earlier was that was not a trustee in a bankruptcy, but that is an exempt transaction. And the way I explained that to you is I said, well, that's an officer of the court. A sheriff in terms of asset forfeiture. So in asset forfeiture, the sheriff can sell securities, and that too is considered an exempt transaction. Again, meaning the state administrator has no jurisdiction or authority over a sheriff in selling or liquidating a security. That's not considered to be a sale under the Uniform Securities Act. And unsolicited transactions are exempt transactions. So, if I'm TD Ameritrade and somebody wants to buy a penny stock and they call me and that's unsolicited, I don't need to worry about the Uniform Securities Act. That doesn't mean, remember the trick, that I, the TD Ameritrade person receiving the customer, doesn't be registered in that state. I do. And so by process of elimination, the answer to this one is D as in dog. Now I would know A, B, and C. So if you're going to turn this into a poor man's flashcard, what I would recommend on this one, the answer is D as in dog. But what I'm really trying to take away as a test taker is, what I need to know, which is that those three are exempt. And so maybe I get rid of this thing that says except. So including the U.S. definition of exempt transactions would be any transaction by any of the following. And so now I have, a flashcard that actually is more helpful to me because I don't want to be studying untruthful information. So that's the takeaway. The takeaway is A, B, and C, not that the answer was D in terms of test taking. 28. An administrator from state B wants to inspect the records from a broker dealer whose home state is state A. Which of the following records may they inspect? Again, this is another question about the authority of the state administrator. So they certainly have jurisdiction authority in state B, right? If I'm the administrator in state B, I'm kind of like, I joke again, right? I'm kind of the god in state B. The SEC is God, state administrators think they are. So there's these 50, demigods running around, if you will. By the way, I would tell you they're mainly attorneys. They're not investment professionals. Anyway, so I certainly have authority in 28 in my own home state. Records in state B. Well, again, I have, authority in state B. There's no doubt about the administrator in state B has, a power in state B. So let's see, 3, all the records of the broker-dealer. None of the records of the broker-dealer since their home office in state A. I don't really care for the answer set, but given that answer set, I'm going to go from 1 and 2 and say, okay, well, I'm not sure about reciprocity as applies to state A, but I certainly know that within state B, I certainly have authority as a state administrator. So I'm going to say 1 and 2, which is choice A. 29. Which of the following statements regarding email communications are correct? I like this takeaway from this question over and over and over again. The North American Securities Administrators Association has said over and over and over again, there's no separate standard for electronic communication than there is any other communication. The communication standards don't change based on how it's being delivered. It doesn't matter if it's text or email or fax, it does not matter. So 29, I think this is a good question. They are sometimes referred to as electronic communications. That's true. And I said, there's no distinction in terms of the regulatory framework of the communication because it's email or it's electronic. So 1 is true. So now I have a 50-50. Customer complaints received our email are not considered to be in writing. No, they most certainly are. Right? Email is written form. Once reviewed and received and reviewed, they can be discarded. No, we have a record retention rule. They must be retained. Yeah, I like this. The answer is 1 and 4. Now, again, you don't want to take away 1 and 4. What you want to do in terms of as a test taker is make sure you know what is the takeaway from the question. So again, we've been talking about making poor man's flashcards. And in this one, what I would do is I would get rid of Roman numeral 2. And I would get rid of Roman numeral 3. Yeah, if I really wanted to kind of beautify it, so to speak, maybe let me just show what else I might do to beautify this thing. Maybe I change this to number 1. And I change this to number 2. And now I actually have a very good poor man's flashcard again. So I like that one. That's a good question. I'd be prepared for something like that. By the way, you shouldn't be jumping into these practice exams until you lay some base knowledge. So sometimes people on the channel are just jumping into the practice exam before they've laid the base by provided by their study materials from Kaplan or STC or Past Perfect or Knopman or Solomon or as training consultants, or the base information made from this free supplement, the playlist for Series 63, Mighty 90 and Who's Your Daddy, or base from, Test Geek Exam Prep LLC's videos and class notes. So, you should be doing this, the activity of these explicated practice exams after you've laid some base knowledge. An agent of a broker-dealer sells unregistered common stock. So this is you're Series 7, you work for a broker-dealer and you sell stock that hasn't been registered. Maybe it's not clear in the question yet whether it's not registered under 33 or it's not registered under the Uniform Securities Act. To an insurance company, well, that helps a little bit because, insurance companies are capable of protecting their own assets, their own interests. So, the Uniform Securities Act and the test is more about protecting retail customers. No office of state. According to the Uniform Securities Act, this would be, so according to the Uniform Securities Act, prohibited because the security is unregistered. So, here it says common stock sold to an insurance company that has no office of the state. According to the Uniform Securities Act, you can't sell unregistered, non-exempt securities to anyone. Now, be careful. You could sell this as an exempt transaction, then that would be different. So again, this one's a little tougher. So be careful. If it was a private placement or something, that might be okay. 31. An investment advisor of a state registered. So state registered investment advisor delivers a brochure. Form ADV Part 2 can be used as a brochure to help people make informed decisions. And, if I don't deliver this in a timely fashion before I sign you up as an investment advisory client, the way I think of this is you're going to have a free look period. And again, this is very much an aim and shoot point and click question. The answer to 31 is D. And again, what I would recommend again is maybe we make this a poor man's flashcard. And night of, morning of, we go through and read all our poor man's flashcards. The CEO. Oh, by the way, Brian Lee, managing member of Test Geek Exam Prep LLC. You don't have to buy any of this. If you have a problem or issue with one of his customer questions, you can certainly put it in the comment box and I'll respond to it. But he's also more than willing to respond to you. Say, hey, I was watching Dean do the explication of your Series 63 paid supplement exam on his YouTube channel, and I'm looking at question whatever. And Dean said it's this, and I'm not quite sure. So you got two people that are willing to engage. At some point, if you don't like my engagement, then I say, well, listen, just take it up with Brian. But his questions, there is a correlation. So good news. Remember, unlike the test prep providers or vendors, Brian and I are not trying to do anything other than help you pass your exam. So the questions are here for a reason. So these are test related, is what I'm saying. So if you are pausing and trying to do this, there will be a correlation of, what you score on this and what we expect you to score on your actual exam. All right, so 32. The CEO of XYZ offers securities of the company to the public and to its employees, and receives remuneration. That's a fancy word for compensation. So, this might be different if you weren't receiving compensation and you worked for the issuer, but once you are receiving compensation, that's going to trigger the idea that you're going to have to register as an agent of the issuer. That might be a different answer, by the way, if it was no compensation involved. An agent overhears that XYZ will report negative earnings this quarter. According to the North American Securities Administrator Association statement of policy on ethical behavior, a big portion of this exam is unethical behavior. And it's unethical for you to be using material non-public information that if other people knew, it would alter their decision. And non-public meaning nobody's had time to evaluate that information. And that seems like that would be unfair to participants in the marketplace. So you should do nothing. You should do nothing. God knows you don't want to run afoul of insider trading, right? A state registered investment advisor is acquired by a federally covered investment advisor. So this is a successor firm. That's what again, the language on the test is challenging. I would be the first to admit that this language is challenging. I had an attorney and he said, man, if I don't pass, it's going to be embarrassing. I go, absolutely, because you are somebody who should understand legalese, right? Anyways, the state registers, all the accounts are then transferred to the federally covered. Now, it doesn't have anything to do with it's a state covered and federally covered. You should definitely know it's very, very testable to know that you can't assign an investment advisory contract without written consent of the customer, the investment advisory client. That is very much something you could very well encounter on your actual exam. So, again, I think that's good fodder for a poor man's flashcard. As we said, then what we're going to do is the night before or morning of is read all these questions and write answers. According to the Uniform Securities Act, which of the following clients may an agent borrow from? So, the Uniform Securities Act is way more stringent than is, the rules for broker-dealer. So 35, the answer is, can you borrow from a bank? Yeah. If it's a bona fide loan, remember, so the bank is not a natural person, and the bank is an investment advisory client, but I go through the normal loan process that anybody else would go through, that would be acceptable. I can't borrow from my best friend under the Uniform Securities Act. I can borrow from a broker-dealer. Broker-dealers have margin accounts. We lend money to customers all the time. Again, if it's a loan and it's a bona fide Latin, you definitely want to know that term, by the way, because sometimes I use that on the test. Let me just put that on here. Bona fide is Latin for good faith. And so what we mean by a bona fide loan is a loan that's actually no different than any other person who wants to get a loan from a bank or a broker dealer. Mortgage brokers are natural persons, right? A living, breathing human being. So you can't borrow money from living, breathing human beings. You can borrow money in a bank in a bona fide loan, or a more BD in a bona fide loan. And so the answer to 35, this is another one I'd be prepared to see on the test, is C, 1 and 3. Let me clean up my slides here. I know you're tired of me. I'm not going to take the time to, get rid of 2 and I get rid of 3, but that's testable. 36. An agent sharing in commissions with another agent may do so. Well, the main thing here is you got to be properly registered. Everybody involved in this transaction has to be properly registered. And so the answer to 36 is C. Disclose the arrangement and consent from the clients. No, if we work as a team together, we would disclose, the commissions or compensation, but we don't have to tell the customer about that compensation. Now we internally split that up in the team, who takes what from the team in terms of that. No, both agents have to be registered properly. That's true, right? 3, both agents are registered through the same or affiliated broker dealer. That's true. And we do need to get consent now. And again, in these multiples, you're not trying to remember 2 and 3. You're is the answer. You're trying to know what it is that you're supposed to know, which is 2 and 3. Under the Uniform Securities Act, an agent in Delaware calls a prospect in Virginia, recommending the purchase of a listed security. The administrators of which state have jurisdiction? So be careful. I think what Brian's trying to trick you on is this question isn't about whether the security is federally covered or not. The question is about whether you have to be registered. And if you have or are soliciting retail clients in Virginia, you need to be registered in Virginia. So an agent means you're a 6 or 63 and you're in Delaware and you're soliciting customers in Virginia. And so the answer to 37 is B. Under the Uniform Securities Act, certain transactions are exempt from the sales literature, advertising, and filing requirements. Which of the following would be included in this category? Which of the following would be included in this category? An isolated non-issuer transaction. What does that mean in English? That means a secondary transaction. So, I'm at the club, you're at the club, and neither one of us are securities professionals. And I sell you an investment I had made earlier in our, local bar we hang out in. The state administrator doesn't care about isolated non-issuer transactions. And so that would be, by the way, it's just not advertising, it's, other things as well. But so B sounds like not a problem. I'm selling to a financial institution or advertising to a financial institution, and a financial institution is capable of protecting their own assets, their own interests. Any transaction executed by an estate, again, there's that idea again. So now I'm an executor or executress of an estate, and that goes into the category that we talked about earlier about the sheriff and about the trustee in bankruptcy. This is another exempt transaction. And if exempt transaction, it means the sales literature filing, right? The main thing that Brian is getting at in this trust question is recognizing transactions that are exempt on the Uniform Securities Act. Now, there's a lot of accounting that's totally inappropriate for a public company that is appropriate for privately held businesses. And so when we're taking a company public, we're going to do reversing transactions between the issuer and the underwriters. For example, In-N-Out Burger is privately held. It's controlled by the Snyder family. It's domiciled in California. And I wouldn't be surprised to find out that In-N-Out Burger is a corporation. The granddaughter, who's now the one running the show, so to speak, maybe she's a huge drag racer, and who knows, maybe In-N-Out Burger is sponsoring a drag racing team. And I, as an underwriter, say, listen, we got to, split that off, get rid of the private jet, do all this stuff. And again, the state administrator doesn't really care about that, because in that example, if I'm Morgan Stanley and In-N-Out Burger is their issuer, who's supposed to protect In-N-Out from Morgan Stanley? In-N-Out. Who's supposed to protect Morgan Stanley from In-N-Out? Morgan Stanley. So 1, 2, 3, 4. I like this one. This is a good question. I like that one. 39. It would not be a prohibited practice under the Uniform Securities Act for an agent to tell a client. So 3 of these things are prohibited. 1 is not. So boy, you really got to read carefully. I would imagine if you've been doing your practice exams, you've got some answers you feel pretty good about, and then you miss the not or you miss the except, whatever the case may be. So can I say they're asking me what would not be prohibited? My commissions are structured so I make money only if my client makes money. Which of the following would not be a prohibited practice? That is certainly a prohibited practice. That's not true. That's almost impossible because the securities go up and down. Registration of securities. Oh my God, you better not say that one. You should definitely know. There's 2 nasty words that we never use in the securities industry. We never use the word approve, and we never use the word guarantee. Now there are exceptions to that, but you should avoid using those words at all costs. C, the fact that she passed her license is ample proof of my qualifications. Listen, you just know looking around at your firm and people who have passed their exam that that's not true. Right? So registered non-exempt securities may probably be sold in the state. That sounds like the best answer given the answer set, right? Which of the following are exempt securities under the Uniform Securities Act? You should definitely have a general understanding of exempt securities. Common stock not listed on NASDAQ or New York, purchased by an open-end investment company by a mutual fund. That's not exempt security. Preferred stock, not listed in a regular exchange, issued by an insurance company. There we go. It's not that insurance get a free pass, it's that insurance companies have a different regulator. So when the insurance company, we're not talking about a variable annuity, we're talking about an insurance company that's privately held, like Esurance, for example, in California. It ended up being purchased by Allstate. But if Esurance wants to sell securities, the regulator isn't going to be the state administrator, it's going to be the Department of Insurance. So 2 is true. Municipal bonds, absolutely. You should definitely know that municipal bonds are. Now, private placements aren't exempt securities. That is an exempt transaction. Welcome to the 63. So number 4 is not an exempt security. That is an exempt transaction. And there's a difference between exempt securities and exempt transactions. I'd also know treasury bonds. I'd also know charitable organizations. It's a laundry list. If you buy Brian's Quick Notes, he does a little thing where he shows you the laundry list of things that are exempt or not. It's kind of like a little flow chart, which you might find very helpful. 41. If an agent receives a written complaint in an email from a customer and believes the complaint is entirely unfounded, it doesn't matter if it's unfounded or not. Right? You're supposed to forward a copy to the administrator. Now, personally, no. No, this is very testable. You tell your supervisor, right? Say, listen, I got a problem with this person. 42. Under the Uniform Securities Act, if an agent in state A calls a client who resides in state B while vacationing in state C, and recommends the purchase of listed security, which states have jurisdiction? So let's just go through this slowly. Agent in state A, so that's where the offer originated. So state A certainly has something to say about that. Let's look at our next one. Who resides in state B, calls a prospect in state B while vacationing in state C. So the client is somebody who resides in state B. The administrators of which state have jurisdiction? Now, I probably would have missed this one. The solicitation originated in state A, but it was directed into state C. And so it's actually B. There's nothing that took place in state B. Now, that's a tough one. That's a tough one. So the answer 42 is B, right? Because nothing happened in state B here. By the way, what Brian is trying to get you to try and think is that state C doesn't have jurisdiction of an offer that was directed to its state, and that's not true. They do have a jurisdiction. According to the National Securities Market Improvement Act, this is known as NIMSMIA. Federal law preempts state laws. You can tell state administrators didn't like this thing. And all the following, except there is no exemptions under the Uniform Securities Act or NIMSMIA for anybody in terms of fraud. So, fraud has no exemptions. You defraud somebody, you're in trouble on every level, from 33 to the Uniform Securities Act to everything. State law and all following except. It did establish federally covered investment advisors. It did establish that investment companies are federally covered securities, as well as NASDAQ and New York Stock Exchange. So yeah, that was what NISMI was all about. When an issuer is registered with the SEC under 33, it's also allowed to register with states. This is very important, testable. It's called coordination. So, the security is not exempt, the transaction is not exempt, and so I'm going to have to register, and I do that through coordination. I like that. That's very much a test question. Qualification would be for something that I can't coordinate or I can't notify. B is just Brian's distractor. There's nothing that would be the right answer to. The issue not be registered with states. Nope, that's not true. Just because you're okay with the feds doesn't mean you're okay with the state. So in terms of the issue, if you're taking a company public and you plan on selling it in a particular state, you need to make sure that you tell the state administrator you will be selling this IPO, this initial public offering, in that state. So that's called coordination. Under the Uniform Securities Act, a surety bond is for which of the following? And a surety bond is, again, to protect against employee theft and fraud. So which of the following can be substituted? Well, if you don't want to post a bond, you can post cash or securities. Yeah, I'm not so sure what I think about that particular question, but you should definitely know it's not commodities. Consensus or service is a different thing, very testable. But given that answer set, C is our best answer. Usually on the test, they frame this the opposite direction. And what the test usually does is says, under the Uniform Securities Act, a broker dealer doesn't want to post cash or securities. What could be substituted? And then you come up with the surety bond. So the actual test has a reverse of that. 46, according to the Uniform Securities Act, guaranteed means which of the following? So, oh boy, the minute we hear the word guarantee, we better be very, very careful. The broker dealer will buy back the security at a price or higher. No. The security has been cleared or backed by the SEC. Absolutely not. The security has a third party other than the issuer. Usually this would be a parent company that's guaranteeing the payment of principal and interest on the dividends. Yeah. So now remember, that third party guarantee of the parent company is only good as the parent company. So C is the right answer. And then we got to make really sure that the person's clear. It's not my firm or myself that's guaranteeing the payment of interest and principal. It's the third party, which is usually the company parent. Kaplan is a subsidiary of Graham Holdings. And so if Kaplan issued a security, a bond, for example, Graham Holdings might say, if Kaplan doesn't pay interest and principal, Graham Holdings will. Graham Holdings is a third party, and I can say Graham Holdings has guaranteed the debt of its subsidiary, Kaplan. So the answer there is a C. 47, according to the North American Securities Administrators Association, a statement of policy on ethical behavior, all the following are prohibited except, and boy, you really want to be careful on these. So, I think the 63, once you figure out what you're being asked, is a lot mellower than if you can't. And then, I had a young lady who said, Dean, she knew what she was being asked, but she didn't like any of the answers, couldn't figure out what the answers meant. So again, it's sort of like learning a foreign language. So that is one of the challenges on this exam. So take your time to get comfortable with what you're being asked. So we're being asked here, all prohibited except, so something in this set is okay, and the other things are not. As a test taker, maybe what I want to use here is what I call my Sesame Street trick. One of these things is not like the other. A lot of people get messed up on A. A is not a problem. That's called arbitrage. Arbitrage is profiting from price discrepancies, happens all the time, and it is not market manipulation. It's not unethical. If I see a security trading at one market at one price and the other at another, that's perfectly okay. Arbitrage is not market manipulation. It's profiting from price discrepancies. And, that does show up where people get confused about arbitrage. So the answer, that's my little timer again. So that means, again, if you're, doing 30-minute breaks, let me just kill this, kill that. And if you're taking breaks, well, here's time for your next break. And if you're, 30-minute study blocks and then the activity is watching a video, and so I'm going to watch a video for 30 minutes and then I'm going to, take a break, this would be time to do so. I'm trying to bring these in a timely fashion, but I think they're really productive. Do me a favor, and if you think they're productive, smash that like button for me. But also just in the comment section, let me know, because this is practice test 1 for the 63, and you might be done by the time we get practice text 2. But if you find it productive, we'll continue to do more practice tests for the 63. This is the first and only practice exam in that playlist, but we now are up to like 3 practice exams in the SIE. On the 7, we're up to 4 practice exams. 65, we got 2. So, we just keep building out the channel in terms of content. So let me know your thoughts. Anyways, you take your break. I'm going to continue to march because I want to get this done in a timely fashion. Let me reset my timer. I'm going to try and bring this thing in under 90 minutes. I think I'm going to be successful here because we're almost done with this thing. Anyways, we said that 47. Let's just look what B is. Intentionally to create market activity. Giving the false impression of volume is a big no-no. So B is a problem. That's called giving him the false impression of volume. C, withholding a market material fact. Nope. Stock always goes up. Nope. Yes, OA. 48, according to the North American Securities Administrator Association statement on unethical behavior, which of the following is a prohibited practice? Recommending a corporate bond for an income customer. That sounds perfectly okay to me. Informing a client that a 12B1 fee of 0.5% is no load. No, that is not true. To refer to yourself as a no load fund, that 12B1, that promotional expense has to be 0.25. So the answer 48 is B. Now, it looks like I got a typo there. That could be me from converting the document into a Word doc. But I do, any typos or things like that are on Dean, not Brian, because I, kind of push him a little bit to, get this stuff. I told him, I said, don't let the perfect be the enemy of the good. He likes to dress things up and, add different questions when we're doing these explications. So, and then I'm saying, hey, listen, there are test takers out there who need this. So send it to me. If there's a typo or two, it's okay. By the way, he's had his contents current. It's just, he's always tinkering, based on, input. So anyways, 49, all the following could result in the revocation means revoking your registration except. Borrowing from retail customers. Yep, that'll get your registration revoked. Excessively trading, that's called churning, that will get your registration revoked. Failing to state all the known facts about an investment when presenting it to a client. It's kind of a trick. I can't present all the known facts to you, and I never do. I have to present the material facts, right? So I'm not going to cloud your mind with immaterial facts that don't have anything to do with whether you're making an informed investment decision. So, I don't have to give everybody all the known facts. I got to give them the material facts. So C is the right answer. 50, which of the following statements regarding registration by coordination is true? So remember, coordination is when we're doing that 33, we're making the registration statement with the SEC. We're going to sell brand new securities to the public. We're going to enter in the cooling off period of quiet time, which is a minimum of 20 days. We're going to accept indications of interest, which are non-binding on all parties. And if we make it through at the end of the effective date. So that's what's going on in question 50. So the registration through coordination, because that's what this is, becomes effective concurrently with the SEC. Which of the following would be considered an exempt transaction? Which of the following would be considered an exempt transaction? The sale of an unlisted common stock. Nope. The sale of a municipal bond to an investment company. That's an exempt security. That's not what we're being asked. The sale of common stock from an issuer to a broker dealer that is not yet registered. That's the one that is an exempt transaction, because if I'm doing business with broker dealers, the broker dealers should be capable of protecting their own interest. And remember, we said transactions between issuers and underwriters are exempt. Broker dealers are underwriters. Not all broker dealers underwrite securities. So not all broker dealers are underwriters, but all underwriters are broker dealers. And we had this early one. I gave you the story of In-N-Out Burger and Morgan Stanley. By the way, my stories are completely made up. So I don't want to get a call from Morgan Stanley and say, oh, somebody watched your lecture and said they're taking an hamburger. But no, I'm just making these things up as we go. Anyways, 52. The administrator may require a minimum capital for which of the following? Well, we very testable to remember that broker dealers have a standard that belongs to the SEC. And so the state, as we said, can impose a net capital standard on a broker dealer that is more than whatever my SEC requirement is. The administrator doesn't require net worth or net capital from an agent or a net capital net worth standard for an investment company. And they don't have a net capital net worth standard for federally covered advisors. I remember the only net capital net worth requirement that the state imposes is that state covered advisor thing about custody, 10 grand or 35 grand. I don't think you're on 63. I don't even think you're going to see the 10 or 35. 53, but it is very tough on 63 to know the state administrator can impose on a broker dealer a net capital standard higher than what I have to meet for the SEC. If cleared by the administrator, all other qualifications are met. An agent's registration, here you go. So kind of a trick, right? You work so hard, you pass your 63. That doesn't mean you're good to go. You're good on noon of the 30th day. Now, if we call the state administrator and they say your registration is effective, well, that will work too. The wife of a customer calls an agent to sell $25,000 worth of securities for a down payment. So there's a red flag here already. I don't see where the wife has any kind of trading authorization thus far. And it doesn't say anything about this being a joint account. So all the account is in her husband's name. So now I find out that it isn't a joint account, because if it was a joint account, I would accept her instructions, but it's not a joint account. She says her whole husband told her to sell the securities. This is very much on the test. It's usually not a wife. It's sometimes the assistant where, they have a scenario where, the client told me to tell you, we don't accept those kind of instructions. Anyways, to comply with the North American Security Administration Association Statement of Policy on Dishonest and Unethical Business Practices, brokers and agents, you should. And again, they have versions of this where, your heart's in the right spot, but you're still breaking the rule. You're still breaking the rule. So 54. Dean, I said it right, but I picked the wrong answer. So the answer here is C, right? We have to take the order from the husband, not the wife. So the answer to 54 is C. And boy, have you done that before? Like Dean just did. I say it right and I pick the wrong thing. By the way, on a channel, if you see something, say something. Every once in a while, I'll post one of these things, and somebody will say, "Hey, Dean." By the way, use the timestamp or the question number to tell me what you're looking at. But they'll say, "Hey, Dean, it's B, not C." I go, "Oh, yeah." And I'll replay it. I'll see that I said it right, and then for whatever reason, brain fart. They're real, and I picked the wrong number. Anyways, 55 under the North American Securities Administrators Association model rule on unethical business practices of investment advisors, investment advisor reps, and federally covered advisors. When may an investment advisor be given discretionary authority to buy or sell securities? Under the investment advisor. Well, you should. I think what I would have done here, struggling with the answer set, is process of elimination. And I just know that all these other ones is, not correct. The answer is A. When I have the actual authority to do so. Broker dealers' discretionary authority is a little different in terms of trading authorization than investment advisors. So the answer is A. 56. Under the uniform model, under the NASA model rule of unethical business practices, there's another one. An investment advisor. So they're asking about the firm this time, not the rep, right? Investment advisor, rep, federally covered, everybody. And we said, borrowing is a little different under the Uniform Securities Act. So let's see. One, a broker dealer not affiliated with an investment advisor. So I have a margin account at a different brokerage firm, which may borrow money. Certainly I can borrow money if I'm a broker and I have permission to have that account elsewhere. I can have a margin account. A bank not affiliated with the investment advisor. Again, that seems like that would be okay. We don't borrow from mutual funds and we don't borrow from closed funds. I think this is kind of the different spin on that same question we had earlier about a bank and a mortgage broker. So the answer to 56 is C. The Uniform Securities Act provides the state administrator may deny the registration of a broker-dealer for all the following reasons except. Yeah, A, definitely, right? Willful violation. That means you knew the rule and you broke it anyways. The applicant is not qualified due to lack of experience. No, everybody has to start somewhere. So, I mean, you're getting your 63. So if that were true, that would mean you'd never be able to start in our business. And so the answer 57 is B. Applicant is enjoying temporary. Oh, that's a problem. You're insolvent. That's a problem. So B. You can't be denied, registration because you lack experience. 58. Again, it's not a derogatory term. Please, it's not a derogatory term. But you, ladies and gentlemen, are what we call baby brokers. It's a term of endearment, right? And if B were true, we would never have any baby brokers because, they wouldn't be able to get licensed because they don't have experience. 58, which of the following is not included in the definition of a security under the Uniform Securities Act? I like this one. I like this one because life insurance is not a security. It shouldn't be sold as a security. It's a non-securities product. So, I'm not a big fan of the answer set, but, I like the takeaway. Life insurance is not security, shouldn't be sold as investments. Commercial paper is a security. It's exempt, by the way. 270-day max maturity. So pre-organization certificate is an exempt transaction. That's not what we're being asked. A variable annuity because of the embedded mutual fund, the separate account, is a security. It's a mutual fund with an insurance wrapper. The thing that makes it a security is that embedded separate account, which is a mutual fund. 59. An agent wishes to be able to share in the profits or losses in the customer account. Which of the following requirements must be met? Again, on the broker-dealer side, I don't know of any firm that would allow this, but the actual answer on the broker-dealer side is with written consent and proportionate capital, that would be okay. Now, I don't know of any firm where that's actually the right answer. So welcome to 63 fantasy land. At least when you pass the 63, you get to leave Series 7 fantasy land. Dean here is stuck permanently. 60, our last one. It will be considered unethical and dishonest business practice for an agent registered with a broker-dealer too. So 3 of these things are okay, and 1 of these things is not. It would be considered unethical for an agent registered with a broker-dealer to effect a securities transaction not recorded on the books after having received written authorization from the firm to do so. So that is not a violation called test question selling away. Selling away is when I do a transaction not recorded on the books without permission. So they say an agent of a broker-dealer sells an investment not sponsored by his employing broker-dealer without permission. This is a prohibited practice known as selling away. That's not what took place in number A. I asked my firm, can I have permission to solicit customers for an investment not sponsored by the broker-dealer? And if I have written authorization, that's fine. And my firm would send a letter to every one of these customers saying, listen, this is not, a sponsored investment. You lose your money, don't come whining to us. B, attempt to convince a client that Pacific Mutual Fund is suitable. Yeah, we do that all the time, right? That's part of the sales process. Trying to lead people to good decisions. That's not manipulation. C, purchase their stock for her own account, knowing, that's a problem. It's about to be processed. That's called front running. Front running is trading ahead of customers, and that's a big, big no-no. And so the answer here is C. D is a problem, but that's actually not, a dishonest, unethical business practice, right? So the answer to 60 is C. That's our best answer given the answer set. Okay, so it looks like I brought it in at a little over an hour. Again, we upload to the channel. I'll probably be uploading this in our normal routine uploading schedule. I hope you're finding it helpful. Like I say, please let me know in the comments what you'd like to see next. I told you, just want to remind you, 3 links I'm going to be putting in the video description. I'll also pin a comment with these, a link to Test Geek Exam Prep LLC, where you get a 20% discount with Guru 20. If you want the PDF of the exam we just explicated, as well as Brian's rationale, his rationale, my rationale may be different because, I'm not trying to read you his rationales. I'm just trying to give you my spin, my explication on it. That is $20, but with the discount 16. If you are interested in the quick notes, which is his, where he goes through it's, X number of pages. And it actually covers not only includes the exam, but also commentary and additional practice problems, which I think are pretty good as well. After each little subject or topic in the quick notes, he gives you a sample question or two. If you want to do that, that's $29.95 with the 20%, it's $24. And I remember, Brian is a paid supplement and I'm a free supplement. And if you're going to use a paid supplement, I think he's a wonderful paid supplement. It's that bridge from the test to your study materials. And then if you want to go all in with Test Geek Exam Prep LLC, that would be the practice exam, the quick notes, and his videos on Teachable. You can check those out when I provide the link. That would be $79 with our 20% discount. That ends up being, I think it's $63.20 or something. So that is going to be available. And I told you, please check out Mighty 90 minutes on the Uniform Securities Act. I'll post that link, and please check out Who's Your Daddy? That's about, this idea of federally covered and state covered investment advisors. You're into the 90 minutes on the Mighty 90. That's why it's called the Mighty 90. But boy, that is, I'm really proud of that lecture. It's really popular. It's really target rich. And no surprise, I'm, impressed with my own lecture. And then the other one is Who's Your Daddy? And again, I think it's pretty spot on as well. So those are the 2 or 3 things that will be available to you. Okay, so I'll see you next time. I hope you found that helpful. And this will be up shortly on the channel. Oh, I forgot one last thing.